Good afternoon, everyone. My name is Keith McNutt, and I'm the Executive Director of the Entertainment Community Fund's Western Region. Welcome to our webinar on managing debt after a disaster. I would like to say first a thank you to the coalition of unions, guilds, and associations that have joined us in this effort to continue providing information and education on topics central to everyone's recovery. I think it's fair to say on behalf of all of the members of the coalition, the unions, as I said, guilds, associations, and the nonprofits in the entertainment industry, that we all remain here dedicated to providing the support, education, information, and assistance that we can to help our community recover from these terrible fires. Um, for those of you who are joining us for the first time in one of these seminars, this is the fourth in a series of webinars we've produced with our coalition partners. The first topic was on FEMA assistance and the Small Business Association and their assistance and loans. The second was on disaster unemployment. The third was on landlord-tenant issues, and now today on managing debt. So those past webinars are all available on our website or the websites of the co-sponsors of this event. Um, I also want to say a tremendous thank you to our friends at Public Counsel who provided the information on the landlord-tenant webinar and are providing today's information for us with our staff person, Rebecca Selkow. So I will turn it over to Rebecca now to make introductions and begin the program.
Thank you. Thank you so much, Keith. Hi, everyone. As Keith mentioned, I'm Rebecca Selko. I'm the Director of Financial Wellness with the Entertainment Community Fund, and we are so glad that you're here for today's webinar, Managing Debt After a Disaster. If this is your first webinar in our series, welcome. And if you've been with us before, welcome back. We are absolutely delighted to have with us today speakers from the nonprofit public interest law firm Public Counsel, who've been working to educate and support our community in the aftermath of the fires. But before I get to our speakers and we get into our content today, I just want to give a quick overview of how we're going to use our webinar space and talk about a few additional resources. Closed captioning is enabled for this session, so just look for the icon on the bottom toolbar of your screen to toggle closed captioning on or off. We are going to be using the Q&A feature today to curate and respond to your questions related to today's topic. Click the Q&A icon on the bottom toolbar of your screen to access that. You do have the ability to upvote questions, so if you would like us to answer a question that someone else has asked, just click the thumbs up below that question so that we know what you'd like to know more about. And we will get to as many questions as we can. Just know that we may ask specific questions in a more general way. You are also welcome to submit any question you have anonymously. If you do wish to submit a question anonymously, we recommend clicking anonymous first before you begin to type so that you don't accidentally submit a question with your name appearing. The chat feature is disabled for participants for this session, but our team is going to be using the chat to share resources and links, so keep that chat open and you're welcome to cut and paste any information from the chat into another document for your future reference. All of the information, all of the links that we share in the chat today will also be shared in a follow-up email. The agenda for today's webinar is being pasted into the chat for you. And just know that we're going to be doing Q&A at the end. This is approximately 90-minute session. We're hoping to reserve about 20 to 30 minutes for Q&A at the end. And during that time, I will be posing questions to the presenters. You are welcome to post your questions in the Q&A anytime you have them. This webinar is being recorded. It's going to be shared in our Entertainment Community Fund client portal, as well as on our website and through all of the community partners who are co-sponsoring today's event. The link to access the recording is also going to be shared in that follow-up email. So before we get to the content for today, just want to mention the other resources that we have available to you. As Keith mentioned, this is the fourth webinar in a series. The other 3 webinars are available on our website and in our portal, including navigating FEMA, understanding disaster employment, and understanding your rights as a tenant. Just to highlight, the deadline to apply for disaster unemployment assistance has been pushed back to June 10th, 2025, and this is per the EDD rep that we have been corresponding with. The links to access those recordings as well as EDD are being posted in the chat. And we cannot highlight enough that if you have questions about FEMA, the SBA, or your unemployment application, it is important to privilege the time. Go to the disaster recovery centers while they're still open. The disaster recovery centers are open Monday through Friday from 9 a.m. to 6 p.m., Saturdays from 9 a.m. to 4 p.m., including UCLA Research Park West on West Pico Boulevard in Los Angeles, and the Altadena Disaster Recovery Center on West Woodbury Road in Altadena. And we have also heard that this site, the Altadena site, is particularly helpful. At these sites, you'll get to speak with an actual live person who can help you navigate applications, review, answer any questions you may have regarding any of the systems. If you need any help accessing that support, please reach out to us. The Entertainment Community Fund continues to offer a weekly virtual drop-in space. We call that Recovering Together, and it's every Tuesday from noon to 1:30 p.m. Pacific time through the month of May. This is an opportunity for our community to come together, to connect, to listen, to share with one another as we navigate the phases of recovery. Everyone is welcome to join, and the link is being posted in the chat and can be accessed on our website and via our client portal. Finally, the Financial Wellness Program of the Entertainment Community Fund offers between 5 and 10 workshops every single month on budgeting, managing cash flow, managing debt, building credit, managing student loans, the basics of investing, tax prep, the psychology of money. And we also offer free, confidential, individual financial wellness counseling and support to those who have completed certain prerequisites. Coming up in May, we have a workshop called Managing Student Loans in Uncertain Times. That's on May 14th. We also have Managing Debt and Credit coming up on May 8th and May 15th. And we look forward to offering more resources to support those impacted by the fires, so stay tuned. All of our financial wellness offerings are designed specifically for entertainment professionals, and they are completely free for everyone in entertainment. All of the community partners participating in this event are offering a wide range of support and services, including emergency financial assistance, mental health support, and practical help connecting everyone to resources. Again, we will be sending a follow-up email with all of the resources highlighted today. There are numerous ways to stay connected and in touch with each other and with your community. So if you are feeling overwhelmed or need some help or some support, we hope that you will reach out. And now it is time to turn to today's topic, managing debt after a disaster. With us today are attorneys Danielle Garcia and Elizabeth Gonzalez of Public Counsel. Public Counsel is a nonprofit public interest law firm dedicated to advancing civil rights and racial and economic justice, as well as to amplifying the power of our clients through comprehensive legal advocacy. Their staff and volunteers seek justice through direct legal services, promoting healthy and resilient communities through education and outreach, and support community-led efforts to transform unjust systems through litigation and policy advocacy in and beyond Los Angeles. Public Counsel's Consumer Rights and Economic Justice Project provides direct services to consumers and homeowners who are seeking assistance with mortgage servicing issues, reverse mortgages, foreclosure prevention, predatory financing for home improvement work, consumer debt collection, medical debt collection, student loans, identity theft, bankruptcies, and so much more. And they will be talking a lot more about all the amazing work that they do, how you can access their services when and if they are needed. But for now, please join me in welcoming Danielle Garcia and Elizabeth Gonzalez. And thank you both so much for being here and for leading our discussion today.
Thank you, Rebecca. We're happy to be here. Let me just pull up the slides. Sorry. So managing debt after a disaster. This presentation, just to let you know, is for informational purposes only and not intended to provide you legal advice. If you need specific legal advice, you should consult an attorney. First and foremost in this time, take care of yourself. If you don't want to talk to debt collectors or just can't, you do not have to. If you cannot afford to pay credit cards or personal loans, don't. There are protections available for you, your income and your bank account, and you need to make sure that you're paying for necessities and things that can result in something being lost, such as your home or a rental unit, utilities, your car, food. These are the things that should be most important to you at this time. If you have a credit card that has purchase insurance, which you might be able to find in the credit card agreement or somewhere online or by contacting the credit card company, you can find out if you have purchase insurance that might cover something you've lost in the fire. You do not have to explain why you are calling to ask about this coverage, and you should be sure to not admit to owing anything after the disaster, as there could be mistakes and fraudulent transactions on your account, and it's just not something you need to be getting into at this point. You should be focusing on finding out what protections they have available for you. If you have the time and energy, you should review your account statements to look at any pending charges. There could be things that you want to dispute, and you have a limited time period to do that. As I mentioned previously, this is a time when we see a lot of fraud going on. And so you want to be sure that you're catching these things as soon as possible. And it's just generally a good idea to keep an eye on your statements for any purchasers or charges that might have gotten on there by accident. You can review your credit report at annualcreditreport.com and get copies of all of the credit reports from the three major credit reporting agencies. It is for free, and you can do it, despite the name annualcreditreport.com, you can do it more frequently than annually. If you see any accounts that you do not recognize, you should dispute them with the credit card company that is listed or lender that is listed, as well as the credit reporting agency. If you are current on your debts before the fires, but you cannot pay them now, you can contact your creditors and ask for a forbearance. You should ask for a forbearance of at least 3 months and have that done without interest or penalties. If you are behind on your debts before the fires and you still cannot pay, you do not need to pay them. Before making any payments, make an appointment for a free legal clinic that assists with debt collection, such as Public Counsel. If you were behind for a significant period of time before the fires, you might never have to pay that debt because the law limits how long a creditor has to sue you on an unpaid debt. Typically, this time limit is about 4 years. So if you haven't made a payment on debt in a really long time, it might be too late for them to do anything. But be careful, because if you make a payment on the debt, that restarts the time limit. So if you're contacted by a credit collection agency and they're saying, just make this one payment and everything will be fine, think about that long and hard because you might be restarting a statute of limitations that allows them to sue you from that time period onward. Another thing to think about is taking out a new loan to pay an old debt. If that old debt is beyond the statute of limitations that I mentioned, the 4 years, taking out a new loan puts you in a position with a new debt that you have to deal with that will have a new time frame to for them to sue you if you fail to pay that debt. You might also be exchanging something that is no longer accruing interest for something that does start accruing interest. Once again, a free legal clinic that assists with debt collection can help you determine what your best course of action is in that situation. You may be concerned about your credit history and your credit score. Well, credit scores at this point really only matter if you're looking to incur new debt. And generally, 7 years after your last missed payment, the debt falls off your credit report. So if you're talking about a debt that has been out there for 5 years, you may only have 2 more years to wait before it falls off of your credit report and ceases being an issue for you. But if, as I mentioned, you take out a new loan to pay off old debt and then cannot pay that, you've started that clock over again. If a debt collector is contacting you, there are laws limiting what debt collectors can say or do, such as threatening you or using foul language. They cannot contact you at all hours of the night. These are things to think about. If anything is happening like that, you should write down in a log every occurrence of these bad behaviors and keep copies of all text messages, phone messages, letters, etc. If the debt collectors keep contacting you, you have the right to ask them to stop. And we'll talk a little bit more about that. You do that by issuing what's called a no contact letter to them. And they have to cease contacting you at that point until you notify them that you want to have any contact with them. Or if they sue you, then that is something separate from the no contact requirements. This is just as to debt collectors and collection agencies contacting you outside of a legal situation. You also have the right to ask the debt collector for more information about the debt, and that can be combined in the letter asking them to stop contacting you. You can ask them to what we call verify the debt and provide more information so that you can determine whether or not it is in fact a valid debt that you may have some responsibility for. Often we see a lot of fraud in in situations like this where we're talking about debt collectors coming after people. A lot of times they may be dealing with a debt that is very, very old and you don't recognize it, so you might need to get more information. But it might also be something that's completely fraudulent, and so you have the right to get more information about what that debt is, such as the name of the creditor, the amount that's owed, any original creditor if the debt was bought, and how to dispute the debt. You should never give financial or personal information to a debt collector, especially if you have any questions about whether or not they're legitimate. Even if they are legitimate and you do feel that you owe the debt, you do not have to give them personal or financial information. If a debt collector cannot tell you the name of the creditor, the amount you owe, or how to dispute the debt, it could be a scam. Debt collectors operate on a system of trying to scare people into paying debt that they may or may not owe. So sometimes they will threaten you with jail time. They may tell you someone is coming to your house to give you a lawsuit or use abusive or harassing language. All of this is what they are doing to try and scare you into paying them something. As I mentioned previously, paying anything on a debt can restart the clock running on how long the creditor has to sue you. So you definitely don't want to be doing that. And you definitely don't want to be paying any money on a debt that may not be yours or may have other issues with it. You cannot be sent to jail for not paying a credit card or a loan. And your wages cannot be garnished and money cannot be taken from your bank account to pay a credit card or a loan unless there is an actual judgment against you. A judgment is a legal document from the court saying that you owe a certain amount of money. It is not just a creditor saying that they have a certain amount that you owe them. That is not a judgment. Even if you get legal papers for a credit card or loan that you may have taken out, there isn't a judgment at that point in time. A judgment comes later. And even if there is a judgment against you, as I mentioned previously, your income and bank account may be protected. There are statutory protections for wages being protected up to a certain amount and for bank accounts being protected up to a certain amount. Even if you exceed those amounts, you can also get protection for your bank account and your income by filing certain types of paperwork. If you have been sued and you received the lawsuit before the fires and have not yet responded, look for the phone number of the attorneys on the complaint. It should be in the upper left-hand corner of the complaint. You can contact them sometimes by email, sometimes by phone to get a 30-day extension to respond. You can ask for any amount of time that you want to extend to respond, but definitely they should give you at least 15 days and shouldn't have that much of a problem giving you a 30-day extension given the situation. However, this only applies if you were actually handed the complaint or someone in your home who you live with was handed the complaint and then a copy was mailed to you. That is called service. And if those things did not happen, you may not have to do anything at this point in time. You can, if you've been sued, agree to pay something on the debt, but you should never agree to pay anything that you cannot absolutely afford. And what you should also realize is that if you pay less than the amount that's owed and there's a settlement agreement for it, the rest may become taxable income. So the amount that you didn't pay. Um, that doesn't always have to occur, but it can occur. And so you should consult a tax professional if you're ever in a situation where you're entering into a settlement agreement to pay anything less than the full amount of the debt that you owe or may not owe. You can also file a response to the complaint. Filing a response to the complaint gives you some breathing room because a trial will then be set, and it will be set for typically about a year from the time the complaint was filed. So you get usually quite a bit of time to figure out what you want to do. In the response, if you have defenses, you can explain what those are. And if you're not sure why you're being sued or who is suing you, the response can help. You can also do nothing. If your income and assets are protected and likely to stay that way, you may not want to go through the process of litigation. There are hearing dates to go to and other things you need to do potentially if the litigation goes forward, and maybe you have all the protections you need and don't want to go through that hassle. As I mentioned, the income protections are on your wages and your bank accounts by law, as well as protections for other kinds of income, such as Social Security, unemployment, and other governmental benefits. Those amounts cannot be taken by the creditors. If there is a judgment against you, as I mentioned, there are various laws to protect your income and bank account. So the amount of disposable wages that you have per week that cannot be garnished is $792 roughly. It depends actually on the um, minimum wage where you work, so it could be higher than this. Disposable wages is your wages after required taxes and other state assessments and governmental assessments are taken out. So if you're earning close to the minimum wage, you're actually probably going to be completely protected um, because you've got this cushion of the disposable amount, and the calculation of this 792 is reached by taking a certain number and multiplying it by the minimum wage that you earn. Uh, this amount increases as the minimum wage increases. So again, your protections float depending on what the minimum wage is where you're working. This is an automatic protection. You don't have to do anything to get this. Your employer's payroll processing company should know what the right calculations are to protect you. It's possible that they do not, so you should always check with them if you do receive any kind of wage garnishment order to make sure that you're protected up to, they know you're protected up to the minimum amounts provided by statute. Even if you earn more than this amount that's calculated here, this roughly 792 per week, only 40% of the amounts that are in excess of that can be garnished. And as I mentioned previously, you can ask a court to protect all of your income if you can show that you need it for your and your dependents' support. You do have to go to file something with the sheriff's office if there's a garnishment or a levy to get this protection. but it is something that's available to you if you can show that you need the money for your dependent support. Also, as I mentioned previously, government benefits are protected, and amounts that are coming in from, say, Social Security or something like that are protected automatically in your bank account so long as those amounts are not commingled with other funds, so that the bank can see that the only funds going into that account are governmental benefits. So if you are receiving income from multiple sources and one of them is a government benefit, it might make sense to segregate that money. As I mentioned, there are the protections for your bank account. First of all, up to $2,170 of any money is automatically protected, and that amount changes every July 1st. Typically, it goes up. And then 2 months worth of governmental benefits are protected if that's the only money in the account. There are ways to protect more than what is automatically protected. As I mentioned, you can file paperwork with the sheriff's office, who it is the levying officer, to ask a judge to look at your financial situation and determine whether or not you can actually afford to have any money taken from you. Your home and car can also be protected from a judgment. Generally, your house cannot be sold to satisfy a lien because of a regular consumer debt. So even if a creditor threatens to put a lien on your house, that lien is not necessarily going to mean that they're going to do anything with it. Typically, they have to wait until something happens with the home, like a sale or a refinancing, in order to get any money to satisfy the lien that they file. So if your assets and income are protected, the only way the creditor can get money from you is if you give it to them voluntarily. And as we mentioned in the very beginning, you should be paying yourself first. So all of the things that you need to live on a day-to-day basis, rent, mortgage, food, utilities, car, that's the money that you should be using on those things as opposed to giving it to a creditor who might never get any money from you anyway. People often ask us about debt settlement and debt consolidation. So if you do not have the money to pay your debts, as we mentioned, you do not have to. But before agreeing to debt consolidation or debt settlement, you should know that what they do is they ask you to stop paying all of your debts, and then they take a certain amount of money from you that they kind of store away to be used to negotiate with those creditors to pay off what you owe. But there's no guarantee that this will work. There's no guarantee that the creditors will deal with them. There's no guarantee that the amount of money that they have you pay or put away in a sort of a savings type account will be enough to settle, will be enough for the creditor to settle with you. Often the payments that they ask you to make are very high, sometimes over $500, and you can still be sued on the debts while they are taking this settlement arrangement situation, while they are trying to negotiate. The creditor can decide that they don't want to negotiate or they don't want to wait, and they can sue you on the debt. Once again, any amount that's forgiven from your debt that's paid can be considered taxable income and can affect benefits that you get that are based on income and asset levels. If you do decide to choose a debt settlement company or a debt consolidation company, do not sign anything that you do not understand. Often they rush you through signing many pages of documents in a minute, and they want you to do them all online and not read them, and they want you to rely on what they tell you is in the documents. But please be careful and review everything very carefully, um, because these are very complex or transactions, and you need to know everything that's going on including where your money is going to go, what happens if you are sued, what happens with the money you're putting away to use to pay off these creditors. Oftentimes, there is a fee charged for monthly to put that money away in a account to hold. So it can get quite expensive. Also, you need to understand how they get paid. They take typically a percentage of the total amount of the debt, not the amount that they save you, but the total amount of the debt. So it's very important that you read everything very carefully and understand exactly what you're agreeing to. If you have questions that they won't answer, that's a red flag. And if you do not know exactly where your money will be going or how the company will try to settle your debts, you should be very careful. And now I will turn it over to Elizabeth.
Thank you, Danielle. Hi, everyone. So nice to be here. I was an actor in a prior life. I was a theater administration in a prior life, so I'm very happy to be here. I'm going to talk to you a little bit about bankruptcy. We're also going to talk a little bit about student loans, given everything that's going on in the world right now. So the first thing that I want you to think about is before you consider bankruptcy, think about whether you are already protected. So Danielle went over a lot of the protections that California and the federal government provide for wages, for bank accounts. And the reason, especially in the state of California, that we have such generous protections is the legislature decided they don't want consumers to have to rush to bankruptcy just because there's a credit card judgment against them. So that's why the protections are pretty generous. A lot of times people who are considering bankruptcy, they're having issues with one or two big debts, but they use other credit cards and are able to pay those off. The challenge that people don't realize is if you decide to file for bankruptcy, all of your credit cards get shut down. You don't get to keep one. So if you are in a position where you are relying on credit cards to go month to month, bankruptcy doesn't make sense, right? Because if you don't have that credit card, what are you going to do? The other thing, going back a little bit to Danielle's discussion about credit reports and what about my credit, most people don't know that if you file a bankruptcy, that goes onto your credit report for 10 years. So if you're close to that 7 years of the debt falling off the credit report and you file a bankruptcy, instead of waiting for that debt to fall off, you're now adding a negative trade line for 10 years. And because of this, when you file for bankruptcy, it makes it very difficult to obtain affordable credit. Notice I don't say difficult to obtain credit because you will be able to get credit after you file a bankruptcy. It's just going to be at very high interest rates, terrible terms. And the reason for that is lenders know that if you get a discharge in a bankruptcy, you can only do that once every 8 years. So if they get you into a credit card or a bad loan a few months after you file for bankruptcy, they know you are stuck with that for 8 years. So you're sort of like the best thing for them at that moment. Even though it's not supposed to work this way, the reality is that filing a bankruptcy can make it difficult to find a place to rent. It doesn't make a lot of sense. What should happen, right, is the landlord should say, oh, they filed for bankruptcy, so they don't have any debts to pay, so they're only going to have to pay me. That's not how it works. Unfortunately, they just see that negative trade line and say, this person's a risk. So if you're thinking, oh, I want to wipe out all this debt so that I can make it easier to find a place to live, just keep that in mind. Next slide. Also, the petition process and the whole bankruptcy process is very, very long. The petition itself is over 60 pages. When you add in the detailed instructions that the court has put together, you're looking at 100 pages of stuff. So think about it right now, especially if you have been directly affected or indirectly affected by the fires. is this something that you want to be dealing with right now? Especially for artists, some of you might be working some freelance jobs, some of you might be renting out a camera or other pieces of equipment to make some money on the side. Those kinds of transactions can raise some eyebrows in a bankruptcy petition. So if your bank statements have a lot of Zelle, Venmo deposits, withdrawals, even though that's a perfectly normal thing these days, the bankruptcy world hasn't quite caught on. And so they'll ask, well, what is this $500? The other thing is, if you've used credit in the last 3 months, you have to report on the bankruptcy petition, not just all of your income, and that's not just your W-2 income, that's not just your 1099 income, that is if you walk dogs, that is if you do a side hustle where you're getting paid in cash. You have to report all of that. You also have to report any payments that you have made to creditors over a certain amount in the 3 months prior to bankruptcy. And credit includes things like using Dave or Chime or Afterpay. Anything like that is considered credit. And the reason that that's important is if you do end up filing for bankruptcy and you've made these payments, that could get you into trouble in the sense that the bankruptcy trustee is going to ask you, well, why did you pay Dave and not Visa? Or why did you pay your mom and not Discover? And they might want to go after those payments to spread them out more evenly. So you want to be careful about things like that. Next slide. I know that there is an entertainment credit union. I know that a lot of you might belong to that credit union. I want to be very, very clear about this. If you have any debts with the credit union that you bank with, so Navy Federal, the entertainment credit union, most credit unions do something called cross-collateralization. What this means is, let's say you took out a personal loan. You might not know it, but that personal loan is secured by your checking account, which means that if you stop paying on that secured loan, you have given the credit union permission to just go right into your bank account and take that money. Some of you might know that. Some people don't know that if you have something like a car loan and you continue making the car loan, but you also have that personal loan and you stop paying the personal loan, they can come after your car because they have cross-collateralized. So they can say, this car is securing not just the car loan, but any other loans you have or any other credit that you have with us. So before you even think about filing for bankruptcy, take a look at any credit that you have taken out with any credit union to see if that's the case. Because if you do, a bankruptcy might not actually help you with those debts. The other thing that you want to be sure of is that you're not entitled to any property anywhere in the world, or that you don't have an interest in property anywhere in the world. Most people will say, oh, I don't have anything. But they don't realize that mom and dad have put them on title to their house because that's easier than going through probate. Some people are on their mom's checking account to help with bills. Some people are on their child's bank account because a child can't open an account without an adult. All of those things in a bankruptcy are considered your property and therefore could be looked at as something that the bankruptcy can take from you. So you want to be careful. Next slide. You also want to make sure that whatever debts you do have can be taken care of in a bankruptcy. Any recent tax debt, we're seeing a lot of folks who have tax debt from 2020, 2019. They didn't file the taxes because of the world pandemic. And when they finally did file, they're owing money. That kind of debt might not be discharged in a bankruptcy or taken care of in a bankruptcy because there has to be some time that passes. Child support or alimony, that can never be taken care of in a bankruptcy. If you have any fines or fees that you owe to the government, including tickets, those are not going to be taken care of in a bankruptcy. So if some of your debt or a lot of your debt is focused on those kinds of things, bankruptcy might not actually help you at all. I'm going to pause right here because I'm realizing that I have not yet explained to you what a bankruptcy is, and I am making an assumption that you all know what this is. For those who are unaware, there are two types of bankruptcies. There is a Chapter 7 and a Chapter 13. Most folks who don't have a lot of income and don't have significant assets are going to be filing a 7. In a Chapter 7, when you file the bankruptcy paperwork or the petition, you create something called the bankruptcy estate that is run and managed by the bankruptcy trustee. That trustee's job is to determine if there are any assets that he or she can sell to pay off your debts. You have some protections. You're able to protect a significant amount of equity in a house or equity in a car, but usually not both. So the reason I'm talking to you about these kinds of things is if you have assets or property that you cannot protect in a Chapter 7, you may end up losing them. And that would include your parents' house or your parents' bank account. Okay, so you want to be careful. A Chapter 13 is usually for folks who have income and are able to make payments on their debts. They just need a payment plan. Most of the folks that I deal with do not file 13s, nor should they file 13s because their income is too low to sustain a 13. Unfortunately, most people get pushed into a 13 because attorneys can charge more for that. So just be aware, okay? If you're talking to someone about a bankruptcy and they're pushing you into a 13, think about, wait a second, that one weird lady told me that maybe I should do a 7. Okay, so back to the slides. Other things that you want to think about in terms of property or assets, whole life insurance. So whole life insurance is life insurance that has a value that you can access. That value can be significant. That is considered an asset. And if you do have a significant whole life insurance policy and you file a bankruptcy, you might lose that to the bankruptcy trustee. Intellectual property, the petition asks you for any intellectual property you may have. And so this does not just include, hey, I sold that script. This is, I've got 17 drafts of 5 different scripts in my house, maybe not registered with the WGA. Those are considered intellectual property that you would have to list in value. Same with books, same with music. So if you've done anything like that, or you have ideas for things like that, you will have to put a value on them, because if you don't list them in the bankruptcy and you end up selling that script, the trustee gets to take that money from you. Tools of the trade. So especially for those of you who are in lighting and sound, costuming, some of you may own your own cameras. Some of you may own your own sound equipment. While you can protect the value of a lot of that, you might have something that's way more than can be protected, or you might have multiple things. So you want to be careful before you file a bankruptcy to make sure you have a really good understanding of what is the stuff that I have worth. Even the little things, even the used clothing, you have to list it all. Next slide. So, and these are the risks of bankruptcy, right? So especially for those of you who are still dealing with insurance companies or have started the GoFundMe accounts, depending on what those proceeds are, you may end up losing them in a bankruptcy. Folks who unfortunately lost their homes, they might get an insurance payout. And that insurance payout is usually protected, but only if you end up putting it into another house within 6 months. Unfortunately, the housing market right now is terrible. Rebuilding is terrible right now. So if you have this bucket of insurance proceeds, you may end up losing that protection the longer it takes to rebuild. So just be careful if you are one of those homeowners who got an insurance payout, but you're trying to deal with other debt. Okay, bankruptcy might not be the best option for you. GoFundMe. I will tell you that the bankruptcy code, the laws have not been updated since 2005. So this was before GoFundMe. This was before the internet really took off, right? I'm dating myself. GoFundMe is just considered regular cash, and that can be protected, but only up to a certain amount. So if you've got a GoFundMe account of $40, $50, $60, $70,000, that can be taken away from you in a bankruptcy. Even for those of you who lost your homes, the land is still valuable. The land still has a lot of value to it. And while there is a significant protection for land, you just want to be careful because, again, if you're not able to build in a quick enough manner for the bankruptcy trustee, they might consider that land an asset that they can sell. So you don't want to risk that happening. This is a big one. If you owe money to your friends and family, you will have to list them and the debts on the bankruptcy, and that means they get notice of your bankruptcy. You don't get to say, oh, I'm not going to include them because I'm going to pay them back. You have to include all of your debts. And so if it's a concern that someone you owe money to is going to get notice of the bankruptcy, maybe it doesn't make sense to file a bankruptcy. Okay. So just think about all of these things. Next slide. If you've given or transferred any property, there are different timeframes for different types of property, but in some cases, the timeframe can go back 10 years. This can create problems. We see this a lot, unfortunately, when there has been a divorce settlement where one spouse is keeping the house in exchange for not having to, not receiving alimony. If the spouse who did not keep the property files a bankruptcy, and that marital settlement agreement was 3 or 4 years ago, the trustee can actually go in and undo that, take the house and sell it, because that is considered a transfer not for reasonable value. So for those of you who have gone through recently a divorce, even if it was through a marital settlement agreement, look at what property was transferred, because any property that was transferred, even as part of that court process, can be taken from the by the bankruptcy trustee. If you've given things to people, whether it was, you transfer title of your car to your kid, that's going to have to be listed. And depending on how much the value, how long ago it was, the trustee might take the car. So you want to be careful. Even though it may seem like it's been a really long time since these fires, they're still recent. And the thing that I want everyone to at least take away is bankruptcy is always going to be an option, okay? Bankruptcy as a concept in terms of a way to get rid of your debts will not be going away. So you don't have to file for bankruptcy now. You can wait 6 months, you can wait 2 years. Maybe you don't need it in 2 years, and that would be great. So don't rush into this because it is a huge financial decision that can result in some pretty significant consequences. We do have a bankruptcy clinic twice a week that you are welcome to set up an appointment for. We will give you a 30-minute one-on-one consultation to hear what questions you have specifically. And that's a free clinic. So if you are considering it, you're thinking about it, make an appointment. Maybe we can help you out. Okay, next slide. So here are some alternatives, because I think a lot of you are saying, okay, but then what do I do? If you are a homeowner that was affected by the fires, you have a mortgage, even if the house is damaged or gone, you are still responsible for paying on the mortgage. Reach out to your mortgage servicer. Most of them are providing automatic 3 to 6 month forbearances while folks are dealing with the insurance process. So if you haven't done that, do that now. If you have a car loan and the car was damaged or destroyed in the fires, you can reach out to the finance company and explain what happened. Perhaps there's gap insurance, perhaps some of your other insurance is going to cover it, but you can reach out to them and ask for forbearance or deferment. Okay. If it wasn't damaged, but you just don't have the ability to pay because of everything else that's going on, call the finance company and say, look, I was affected by the fires. Can you give me a forbearance for 3 to 6 months? Interest is still going to accrue. You're still going to owe money on the debt, but at least you might not have to pay for a few months. If you have creditors harassing you, send them a no contact letter. It was put in the chat earlier. It's on the links at the end of these slides. Feel free to add something saying, I was affected by the wildfires. I don't even know that this debt is accurate, because you don't know. The mention of the unemployment benefits, apply. A lot of folks think, well, I'm not going to qualify because the worst they can say is no. And the best they can do is say yes and give you $450 a week or every 2 weeks. So apply for benefits. Folks, I'm hearing from folks who are like, I'm going to leave that for others. Others need the CalFresh stamps more than I do. They are there for everybody. If you need them and you qualify, apply and take them. Same with Medi-Cal. If you lost your health insurance, you might qualify for Medi-Cal and not have to pay anything. And these are the things that we pay taxes for. So use the benefits if you qualify for them. Okay. And I'm sure this has been said before, but all of your unions might have some funds for you. They might have food banks. They might have other things for you. Reach out to your community to see if anyone can help you so that you don't have to necessarily go to bankruptcy. Next slide. Okay, student loans. We have been getting a lot of people worried about this idea that the federal government is going to start collecting on defaulted loans. I want to explain to you what being in default means on a federal student loan. Being in default means you have missed payments for at least 270 days, okay? For those of you who were in the COVID forbearance until October when it stopped, and you have not made arrangements to make payments, you are getting close to that 270 days. Contact your servicer right away. If you believe that you are in or might be close to default, please get in touch with your servicer. If you can get put on a forbearance while you are completing an income-driven repayment plan, that is going to be the best thing for you. Because if you are in forbearance, it's less likely, it's not a guarantee, but it's less likely that you're going to be on that list, okay? If you don't know what an income-driven repayment plan, go to your servicer, go to studentaid.gov, look at repayment. Income-driven repayment plans mean that the amount that you are required to pay is based on your discretionary income. There are people who have payments of $0. So it is a $0 payment. So you're not making payments, but you are because 0. Those count as payments, okay? If you are having a hard time getting in touch with your servicer or getting in touch with the Department of Education, please contact your elected officials, your Alex Padilla, Adam Schiff, and whoever your Congressional House of Representatives person is. They need to hear from you if you are having a hard time with these government agencies. The more people they hear from, hopefully the more can be done to explain, no, we actually do need people working at the Department of Education. If you are in default and you do not do anything to get out of default before May 5th, which is Monday, you may be on the list for collections. Unlike a general consumer credit card, the federal government can garnish wages, levy bank accounts, intercept tax refunds, and offset Social Security payments without a judgment. So this is why it is so important. If you believe you might be in default, please reach out to your servicer, because all of those things can just be taken. And the protections are not the same for the federal government taking money from you as just a regular old credit card company. If you're not able to reach out to your elected official or they're not responding to you, reach out to Public Counsel. We might be able to give you some assistance as well. I think I have stressed that enough. So can we go to the next slide, please? Other alternatives to bankruptcy. For those who don't know about 211, we do hear some mixed reviews. You know, sometimes we hear from people, it doesn't help me at all. And sometimes we hear from people, oh my goodness, the assistance they gave me is huge. 211 is a referral agency with the County of Los Angeles. If you dial 211 from any phone anywhere in California, you will be connected to the local 211. You can tell them, I need help finding food, I need help with utility bills, I need help with whatever. And they will give you referrals to nonprofits or government agencies that can assist you. If you have received a lawsuit, contact a nonprofit legal services like Public Counsel, Neighborhood Legal Services. There's a bunch of us in LA who can help you with your options and even help you with the response to the complaint and a fee waiver. So you don't have to worry about paying those fees. Next slide. And here are some additional resources. So the first one is how to sign up for our bankruptcy clinic if you want an individual consultation. The second one is some instructional videos on bankruptcy that might be really helpful for you. The third one is some resources if you are faced with a debt collection complaint, including how to respond, how to seek an extension, and a few other things. The fourth one is that no contact letter packet that was posted earlier. And then the last one is how to sign up for a debt collection defense clinic. So if you have received a lawsuit or you're getting phone calls, you're not sure what to do about a debt, you can make an appointment to meet with an attorney for an hour. All of this is free as long as you qualify for our legal services. And I think that was the last slide. Am I right?
You're right.
All right, how about that?
Amazing. Thank you both so much for this wonderful presentation and all of this very helpful information. We just have 2 questions in the Q&A, so we should definitely be able to get to both of them. But folks, if you are still on and still listening, please do take advantage of this opportunity to ask any questions that you might have about the content that was shared today. You can pop those questions into the Q&A, which is located at the bottom. There's an icon for it at the bottom of your screen. So the first question is, what about business credit cards? Can you do bankruptcy on your business credit cards and not affect your personal credit card score? My credit cards don't show up on my personal right now.
So I can take this one. So ish. So if the credit cards are actually in the name of the business, the way to deal with those debts is for the business to file a bankruptcy. So, and that can be difficult because usually the business, if it's not a doing business as or a fictitious name, it's an LLC or a corporation or a partnership. Such entities need an attorney to file a bankruptcy for them. So that can be expensive. If you're filing a Chapter 7 for the business, that means that the business is going to, at the end of the bankruptcy, not exist anymore. So if that's something that you're looking to do, yes, it will affect just the business credit cards so long as the credit cards are only in the business's name. So hopefully that answered that question.
And sometimes those debts can be required to be secured by a guarantee from the person.
Right.
So that can also wrap in the human being into the business's debt.
Right. So if you, as an individual person, guaranteed the credit card, the business bankruptcy is only going to affect the debt as to the business, not as to you individually.
Great, thank you so much. Next question is, do you recommend freezing your credit in order to avoid having credit card companies negatively impact your score if you have to miss any payments?
I don't know that freezing your credit report will affect the credit score, but just at this point in time, generally speaking, and protecting yourself from fraud, that is where it's a good idea to freeze your credit report.
Yeah, under the Fair Credit Reporting Act, credit card companies are required to report accurate information, including missed payments. So if it's an accurate report that you have missed a payment, they have a legal duty to report that, and freezing the credit doesn't do anything about that.
Thank you so much. And we have a question about student loans. I'm going to ask this and then highlight again that we have a webinar called Managing Student Loans in Uncertain Times happening on May 14th here with the Entertainment Community Fund. So hope that you'll join us for that. But for tonight, do you have any information about student loans if you are in the SAVE program that is tied up in the courts?
Yes. You should contact your servicer about getting into a different income-driven repayment plan, because the Department of Education right now is saying SAVE doesn't exist because there's an injunction, and that is technically true, but you still have the right to go into a different income-driven repayment plan. So even though it's not going to be as great as SAVE would have been, you can still sign up for another income-driven repayment plan. Usually it's going to go to income-based repayment, which should still give you a lower payment than your standard repayment would be. So that would be my suggestion now, because technically it had been that those who had applied for SAVE were being put in forbearance. It is our understanding that that might come to an end, so that you will then be required to make payments at the standard repayment. So our suggestion right now is to sign up for another income-driven repayment plan. If SAVE ever comes to be, you can always apply to be in that one when it comes to be.
Thank you, Elizabeth. Okay, what about defaulting on just a couple of credit cards as opposed to doing a full bankruptcy?
Sure.
Well,
Oh, sorry. Go ahead, Danielle.
yes, you don't have to pay those debts if you cannot afford to pay them. And you may be subject to a lawsuit, but as we discussed, there are protections for your wages and for your bank account and for certain other types of income that you might get from those creditors ever getting that money. So it's up to you as to whether or not they get any money. And if you can't afford to pay them, why should they be getting money you need to pay rent, mortgage, food, utilities, car payment, etc.?
Thank you very much. Another student loan question. Do I have anything to worry about if my student loans were forgiven during the previous administration?
I cannot predict the future. I don't think so. I'm trying to be very diplomatic. Anything can happen. I don't think this is where the focus is going to be, because I think there will be very significant litigation that would probably put a kind of immediate stop to something like that, because it's much harder to take something away, that forgiveness, than to give something to somebody. So with the number of debts that were forgiven under the previous administration and the different ways they were forgiven, even though anything can happen, I think that it will be very difficult to claw back that forgiveness, because it would cause such an impact on people. Especially if they were forgiven under like public service loan forgiveness, that was statutorily given. It is going to be very difficult to say, here was the law, we followed the law, the person qualified for forgiveness, we gave them forgiveness a year ago, 2 years ago. That's really hard. But a lot of things are hard. So I hope that answers the question, even though it's not really an answer.
I can say that I appreciate very much your taking a stab at it. So thank you very much. And we have another student loan question. If we are in the SAVE program at the moment, do we need to find a new repayment plan before Monday?
Reach out to your servicer. If your servicer is considered you current because you're in forbearance because of the SAVE program, you'll be fine. I hope you'll be fine. You should be fine. But reach out to your servicer. The servicer is the one that's going to be reporting to the Department of Ed those people who are in default. So if the servicer is continuing to keep you in forbearance, that means you're not missing payments. So you really want to reach out to your servicer. If the servicer is saying, well, we're getting direction from the Department of Ed that anyone who was in the SAVE program has to be pulled out of forbearance, find out about applying for a different income-driven repayment plan. Hopefully that's helpful.
Thank you so much. That is the last question that was posed. I'm going to take one beat just to see if anyone is typing. Oh, here's one. So just let's see. I'm not sure what this word is supposed to be. It says, does selling your credit card as bad as bank? Oh, stealment. Okay. I do not understand the
Is
question.
somewhat so
Starting to say settlement.
Settlement.
Oh, thank you. I'm so autocorrect 3 times the charm. Thank you so much for the person who the attendee who thank you who corrected their misspelling there. Okay. Does settling your credit is settlement debt settlement on for your credit cards as bad as bankruptcy, and does it affect your credit score, or to what extent does it affect your credit score? No worries. Thank you.
Don't drive while texting.
We appreciate you so much for being here and asking your question.
It's got a different effect than a bankruptcy. But as I mentioned previously, they're going to ask you to stop paying your credit cards in order to, as in their minds, bring the creditor to the table to settle for something. But those missed payments will go on your credit report immediately. So there will be a negative impact on your credit pretty quickly.
And even if you try to do it on your own, so there isn't someone you're paying and you're not stopping paying, if you end up settling for less than you owe, that gets reported on your credit report, and that is considered a negative trade line because you're not paying the full amount. And then couple that with what Danielle was saying, that amount that you don't pay is considered taxable income. So you might end up owing taxes or losing some benefits because of that. So it's a kind of apples to oranges. Both of those things, a bankruptcy, settling for a single credit card, or going through debt consolidation settlement, all can have negative impacts on your credit. And I will just repeat this. Let's not worry about our credit score, because credit is just another word for debt. So if you're worried about your credit score, it's only because you want to get into more debt. And if you're in the process of trying to deal with debt, maybe you actually don't want to get into more debt. If you're super worried about your credit score, delete Credit Karma, stop paying money to Experian Boost, ignore your credit cards offering your credit score, because you don't need to worry about that. And if I can just do a little rant on credit scores for like 2 minutes, maybe not even 2 minutes. There is not a single credit score, okay? Even within the credit score furnishers like FICO has 9 different scoring models. Vantage has 9 different scoring models. So if you are looking at Credit Karma, first of all, Credit Karma is owned by TransUnion, which is one of the credit reporting agencies. So take that for what you want. My guess is they're going to be showing you what's on your TransUnion, not your Experian. Experian Boost is owned by Experian. So they're going to give you information based on Experian. And the fact that you can pay money to Experian Boost to increase your credit score should tell you just what a fiction credit scores are, right? So don't worry about your credit score. You don't even know which credit score whatever agency you're trying to apply for credit for is going to be using. So even if you're looking at one and it's fantastic, the landlord might not be looking at that credit score. So let's push away the importance of credit scores. Let's focus on ourselves, and remember that credit is just another word for debt. I'm coming off the soapbox now. Thank you.
It was a beautiful speech, Elizabeth. Thank you. Appreciate it. This is a question about balance transfers. Do you recommend opening a second line of credit to transfer a higher interest rate credit card and receiving a year or so, we know it can vary, of 0% interest? Or is this asking for more trouble down the road? And a secondary question to that, is there any way to stave off or renegotiate a higher interest rate APR from accumulating on a credit card?
As far as doing a balance transfer to get a better rate, it really depends on what's going on with your original credit card. If it's in good standing and you're just changing from one rate to another, and you're gonna maybe close down the credit card with the higher rate, that can make sense. If you've got a problem with the original credit card and say you haven't paid in multiple years, then you don't want to restart the clock on that one with a payment. But it's unlikely that you could be offered a new, better credit rate if you had such an old debt. So I'm thinking probably the first situation is the one that you're talking about, where you've got one in good standing and another that's got just a much better rate, and there's no reason to keep paying the old bad rate if you don't have to. But keeping both of them open might not be the best credit management decision.
And I would also add, read the fine print, because a lot of times those 0% rates are introductory. So if you don't pay it off within the 12 months or the 6 months, you get charged all of the interest from the beginning. So you want to make sure you read that. And then, can you even afford making the payments on a 0% interest rate within a 12-month period? Because if you're going to be struggling making those payments anyway, maybe you could use that money to pay your rent or buy your food. So
Absolutely. I think that is the answer to the, is this asking for more trouble down the road piece of the question. In and of itself, it's not, but it
and
really,
sorry,
yeah, no,
I
go
forgot
ahead.
the second part. The second
Yeah.
part is, yeah, you can reach out to your credit card company, especially if you're still in good standing. A lot of times, credit card companies will reduce your interest rate, or at least give you, like, moving forward, a 0% interest rate on new purchases for 6 months or a year. But most people don't realize they can just pick up the phone and do a negotiation on their own. So just pick up the phone, reach out to them, see what they do, see what they say.
Thank you both so much. Okay, now, oh, here comes another one. This is fantastic, y'all. What do you suggest if you have two credit cards with one bank and you're in good standing with one card, but you get behind on the other card, and then the company decides to punish you by closing both credit card accounts? Is there anything that can be done regarding this? So this is a specific situation, but I think we could expand it to, is there anything that can be done if a company takes a negative action against you with respect to a credit card or multiple credit cards that you have?
I can take a crack at this, Danielle.
Mhm.
So generally speaking, if there was an adverse action taken against you, you have a right to request in writing why that action was taken. And if the company used a credit reporting agency to deliver that action, you have a right to know who it was so that you can get a copy of that credit report. So those are some of your rights under the Fair Credit Reporting Act. Now, a business can make any decision it wants to make, so long as it's not unlawful. If most of the time your credit card agreement that nobody reads when you first get the credit card, I don't read mine, will say, we can do this if that. So most likely you agreed to let the business do whatever they wanted. So there really isn't anything that you can do about making them open an account for you or keeping an account open. But in terms of the adverse action, you do have the right to request information as to why it was taken and what they used to determine that. So I hope that was a general enough answer.
Great, thank you. Taking a beat in case any additional questions come in. Okay, I don't see any more questions at this time. Public Counsel has shared their contact information. We've shared ours, and so please do reach out if you have additional questions or would like additional support. I want to thank Elizabeth and Danielle. Thank you both so much for being here today to share all this information with us. A reminder that we will be sending out the recording of this webinar, as well as all of the links and the resources that were supplied in today's chat in a follow-up email by the end of the week. So keep a lookout for that. So everyone have a wonderful rest of your Tuesday, and we look forward to seeing you again soon. Everyone take very good care.